Thank you for joining us for today's webinar on consumer law cases. As we get started today, please let us know in the chat if you have questions or comments or any technical difficulties. And I am very pleased to be your hostess today. My name is Donna Jones. I'm the President and Director of Associate and Client Experience here at Advocate Capital. And I'm really excited to tell you about our special guest today, Abbas Kazerounian. He is one of the founding partners at Kazerouni Law Group, APC, and the Injury Recovery Group. His areas of specialty are personal injury, consumer rights, and class action cases. He has litigated over 3,000 individual consumer rights cases and is regarded as one of the preeminent consumer rights attorneys in Southern California. His depth of experience, his knowledge, and of course his trial skills make him one of the premier advocates in this area of the law. He has been responsible for over 650 published opinions and has argued successfully many times at the Ninth Circuit Court of Appeals, including the landmark case of Knutson versus Sirius XM Radio. Sorry about that. He's currently litigating a number of cases at the Ninth Circuit, and we are delighted to have him with us. Abbas, thank you so much for joining us today.
Hi, good morning, and thank you for having me. Really appreciate the opportunity.
Okay, perfect. One quick housekeeping item before we get started today. We are not here to give you legal advice, tax advice, accounting advice, any advice really. We are here to provide education and share some best practice recommendations. And so with that, we will get started, Abbas, and if you would, talk to us about the types of cases and how you identify those.
Sure, thank you. So, Donna, when people talk to you about consumer cases, I think there is maybe a little ambiguity of what we mean by consumer cases, because it is a very broad topic. And some people just perceive it as personal injury. And I do perceive personal injury as a consumer type of case, but I think consumer cases are so much broader than that. And what I call true consumer cases beyond personal injuries, which are torts, generally tend to be statutory driven cases. And just to give you a few examples, for example, the Fair Debt Collection Practices Act or the Telephone Consumer Protection Act, TILA, RESPA, and statutes like that were enacted on both the federal level, and depending on what state you live in, you have either sister statutes for some of these federal statutes that I mentioned, or just independent statutes. So for example, in California, we don't just have unfair competition law, we also have the Consumer Legal Remedies Act, which go towards services and goods and things like that. So there's a plethora of statutes are the kind of things that we are looking at beyond just personal injury. So I think as a good starting point, I want to create kind of a foundation for the viewers and the listeners out there of what I'm really talking about. I'm generally, when I talk about consumer cases, not talking about personal injury cases, though they are in that category. I see them as their own subspecialty. And so those are the kind of cases that we're looking at. And as far as identifying these cases, I think irrespective of what area of law you practice in, these cases are probably coming across your desk, but because we have subspecialties, whether it's in real estate, whether it's in personal injury, or whatever the case may be, we are perhaps ignoring those consumer cases, or just because we're not screening for them. So if, for example, you are a real estate attorney and do real estate transactions or litigation, you may have clients that are in disputes with the bank, for example. And there are phenomenal statutes both on the federal and state levels regarding real estate, and the most probably famous one is RESPA. And RESPA gives us a lot of powers that we, for example, don't know. So if you're a real estate lawyer and your client has been in conflict with the bank, you get some type of pre-litigation discovery, for example. There is something called a qualified written request. You get to ask for a bunch of information, which by law, they are basically obligated to hand over to you pre-litigation and without discovery power or subpoena power, which is an immense amount of power that you may have. But if you, and most real estate lawyers would probably know about RESPA, of course, but I'm just giving a crude analogy to kind of what, what I'm talking about. So identifying these cases, it really depends on what area of law you do and what, can potentially come across your desk. And so they're everywhere, in our normal day lives, and it could be even something like a labeling case, or it could be someone being charged more than they are, what they bargained for with the, with the corporation. And so I think it's important to basically keep our eyes open. And obviously, if you're not sure, on the plaintiff's bar of things, we always have, very good listservs depending on what state you are, and there's federal listservs like the AAJ, for example, and things like that, that we can basically share information and say, hey, I saw something, it doesn't sound right, it's a little bit dodgy, I think, but I can't put my finger on it. And of course, our fellow plaintiffs attorneys can, potentially help us screen and spot those cases.
Okay, perfect. Let's keep moving. Why is my, let's see if I can advance PowerPoint. Here we go. And so our next topic, importance of referrals and class action strategies. And so I guess, how would you like to approach this? Separately, or are these topics related?
I mean, I think there is a lot of overlap between the topics and, and on the different slides. So for example, on the previous slide, one of the kind of the bullet points we had is gathering evidence and building a strong case. So in the context of consumer cases, I think one of the biggest things that we as lawyers can do is really educating our clients, because most of our clients, and in fact, a lot of lawyers don't even know what rights we have as consumers outside of our subspecialties, right? And so, and you have to understand the people that we're taking on, on an average day as consumer lawyers tend to fall into, generally speaking, the auto industry, like, the car manufacturers, insurance companies, banks and credit card companies, food and drug companies. And there is a direct correlation. And when you're watching TV, for example, and the commercials come on, really there's a rotation of the, somebody advertising within those 5 contexts, which really means that they are really driving the media and they're driving the lobby on what's being communicated to consumers. They're obviously doing a great job at the legislatures and on the media that we have about how great they are and all the good things they do for consumers, but they're also making sure that the average consumer is not being educated on what their rights are when corporate America has wronged them, and we're at a major disadvantage in this point. And so I know in my practice, for example, one of the things that I really try and do in gathering evidence and building a stronger case is spending that additional time in the screening process. So our intake specialists and our attorneys that do the intake spend that additional amount of time to educate our clients, explaining to them, it's like, I understand that this has happened to you, but you should also do X, Y, and Z, because that it's going to give you that additional bit of power that you may not have to basically like assist you in your case. So in a debt collection context, for example, when a debt collector calls a consumer, they are on a headset keeping contemporaneous records, for example. Well, the consumer is a major disadvantage. So when you're keeping contemporaneous record as a business record, that's a hearsay exception, and they get, if it comes to litigation, that's admissible evidence on their end. So my position to the client is like, why put yourself at a competitive disadvantage in a litigated dispute? So keep a notepad next to your telephone, and when they call you, find out. Don't put yourself at a disadvantage by not knowing who called you at what time and what they were discussing. Take notes. I talked to John from ABC Debt Collection Company at this time, and this is what we discussed. If they're contemporaneous records, you're putting yourself on an even field with these guys. Now, you may not know that your rights are being violated, but bring me those contemporaneous notes and I will figure out what the violation is. That's my job. But you have to help me help you. You have to give me the tools. And unfortunately, a lot of these consumer statutes are built in a way that I can't do anything unless I have more facts. So in a classic example, like a very rudimentary FDCPA violation, for example, is if you've written to the debt collector and said, don't contact me, and they contact you, then at that point, you have standing to bring a lawsuit for a statutory violation of the FDCPA. Now, unless the consumer keeps their phone record and takes a screenshot of when the debt collector contacted them post cease and desist, and then communicates that to me as their lawyer, I don't have the power to help the consumer. Now, this is a crude analogy, but it kind of, the same messaging goes across all statutes and all areas of consumer law. You need your clients to be emboldened and empowered and educated in order for them to gather the evidence to help you, empower you, and give you the tools as the lawyer to be able to assist them. And I think that is the number one tip and the number one thing that I would definitely kind of like, talk to my plaintiffs, brethren and sisters, to tell them, like, this is what you should be doing, because that additional time in that screening process at the beginning and educating the client could basically be the deciding factor in being able to give you that additional piece of evidence or fact or circumstance that changes the direction of whether your client has a case and or whether it is a good case, even if, when you didn't know whether you had kind of like a on the line kind of case, whether it's kind of, it could go by either way. So it's you helping your clients to help you is the biggest thing that I would definitely tell you. Now, going back to the next, the subsequent slide that you kind of talked, that you put up briefly earlier, the importance of referrals and class action strategies. So those all go together, right? So the importance of referrals is obviously very important, because, if somebody comes into my practice and they have, and I'm looking at my clients, through the lens of just, the areas that I do, and forget everything else, I'm taking away something from my client. So why not like try and educate yourself just to have enough information to say, you know what, this could be an antitrust case, right? Like, and like, like there's some some weird things going on with the pricing. I don't do too much antitrust, but I know an attorney that does. So I can still help my client in my area and yet enable them and empower them to enhance their situation by giving them another case. And of course, you have the financial benefit as a lawyer to have the referral arrangements with other attorneys. So I think that's very, very important. And again, it goes back to the screening process and educating yourself as a lawyer, and of course your clients in the fact gathering and the evidence gathering stages. And so, like, it's very difficult to say what our strategy is going to be unless we know the particular facts and circumstances of every single case, and the facts that we have. I mean, like, do they, for example, just as a basic premise, do they satisfy the basic elements of Federal Rules of Civil Procedure, rule number 23? Like, do we have more than 40 odd people? Are there common issues of fact and law? And is the claim that your client has typical of what would be the absent class members? And are the damages going to be something that we can work out on a uniform basis? They don't have to be exact, but we need some kind of formula to be able to do it so that there's no individualized inquiries. And of course, am I adequate and is the client adequate in being able to bring the claim? So if, for example, my client has a pretty a criminal history with moral turpitude on it, they're not going to probably qualify as as a class representative. And if I'm a lawyer that hasn't done too many class actions or any class actions for that matter, I as counsel probably will not be able to qualify as class counsel, because those are one of the elements that are mandated by the rules, whether in most state laws and of course the federal rules. So in order to go to the next stage and say, hey, let's strategize about class actions, like, you need to basically fulfill those basic rudimentary elements before you get into the strategy. And I think at that point, the people that are going to be litigating the class action at that point will come up with the strategy based upon whether the rudimentary elements have been fulfilled.
Excellent. Technology, not my favorite topic, but I know it is very important in this area of the law. And when I see this slide, Abbas, I must get 2 or 3 notices a year about data breaches, it seems like. So I know that's a topic that's on everyone's mind. So tell us your thoughts on these 2 items.
So I am really happy that this is kind of a topic, because this is, at my firm, this is one of the areas we concentrate on. And data breaches generally fall into 2 buckets: medical data breaches and other types of data breaches where people's personal sensitive information has been leaked or hacked by outside scammers and bad actors. And of course, as technology is enhanced and improves literally on a daily basis in modern society, the sophistication of hackers also is improving. And the fact that you're only getting 2 or 3 notices is actually not a bad thing, because it's staggering. Literally on a daily basis, we're getting notice of another data breach by another big corporation. And these are not Mickey Mouse mom and pop companies. We're talking about, think about it. The most famous or infamous data breach was the Equifax case from a few years ago, with over 250 million people in that class. This is a company that is meant to help people protect their credit, and which is ironic, of course, right? And you have hackers that broke into that. You have Capital One. You have these really, really sophisticated and highly technologically advanced corporations that are Fortune 500, and they are getting breached. So that doesn't leave that too much to the imagination, that like how rampant and this area of law is, and it's basically on the front line of consumer law right now. And with that, of course, comes massive amounts of data that are exchanged in discovery. So especially in the class world, we are doing cases where hundreds of thousands, if not millions, of documents are having to be exchanged in discovery and fought for. And so I think it's a multi-tiered conversation, and there's a lot of moving parts. Number one, obviously, data breaches are a reality of 2024 and moving forward. It's just part of life, and it's just about how we mitigate that as companies and as consumers. Obviously, companies need to be spending larger amounts of money protecting consumer data, because there are laws. For example, in California, we have probably the best law for data breaches, the CCPA, which allows for statutory damages, which most other states do not offer. It obviously enables consumer class action practitioners to be able to bring class actions when you have statutory damages, which makes it very, very difficult to defend against. But of course, that brings about, if you do get into the litigation minefield, and this is actually not just within data breaches, it's any types of class action with big corporations where high amounts of data is being exchanged, you need to get into discovery tools and be really exploring how you can search through so much data in an efficient and economic manner. Because looking through a couple million documents alone, just going back to old school litigation where you would get doc review attorneys, is an expensive endeavor. And so I think the more data that there is in the world, the more expensive litigation becomes, and obviously the more vulnerable consumers are as far as data is concerned. So I think it has a lot of negative impacts. And of course, talking about consumer law, data breaches have a ripple effect, of course, because unlike some types of law, you can't unring that bell. Once there's been a data breach or a data hack, the data is out there. You can't undo it. You can't take the data back. Once it's on the dark web, it's on the dark web potentially for perpetuity, and bad actor is going to sell it to bad actor, and so on and so forth. The question is, how can you mitigate against that, and what do you do if you're a further victim of that? So at our law firm, we have a whole department dedicated to identity theft, because that is a direct derivative and a ripple effect of a data breach. So the bad actor gets the personal and sensitive information of an unknowing victim, uses their name, uses their social security number, uses everything to be able to set up these credit lines, maxes them out. And again, most people are not doing the fundamentals right, which goes back to education. Are you pulling your credit report every year from all the 3 credit bureaus, or the major credit bureaus, TransUnion, Equifax, and Experian? Everybody gets a free pull every single year. Fact. But most people don't know that, and most people don't utilize that. And so it's only when they really need something, they need to go buy a new car, finance a car, finance a mortgage, refinance a mortgage, or buy a house, or do something like that, that when the credit is pulled by the vendor that's trying to sell them something, they're like, well, your credit score's in the 500s. I can't do anything, or if I can, the interest rate we're going to charge you is going to be through the roof. And at that point, you're playing, let's put the fire out, rather than being proactive in trying to mitigate any of all of that, right? And even when that happens and you become aware of it, there are a lot of statutes that protect consumers. So, but you have to know how to dispute these issues. The fact that you have to go file a police report, and I think knowing that there are lawyers out there that work on contingency and can help you with something like an identity theft is, again, an educational problem. As you can probably see, there is a theme in this conversation, right? Education, education, education. And it's because the consumer does not know these things. And it's about messaging and branding that as law firms that say, hey, we can help you without you spending any money, because these statutes were designed that way. When people are being hounded by debt collectors, when creditors are putting things wrongly on your credit report, when scammers are there, you're in a vulnerable position that you can't afford attorneys. That is why, you know, the legislatures drafted these statutes so that the consumers have the ability to say, hey, go get the money from the defendants and the bad actors so that I'm not put at further risk and further harm when I'm already a victim of financial fraud. So it's that education that is absolutely integral to our area of practice, that whether it's at the intake process, whether it's after the intake process, and of course messaging it out there so that consumers even know that they have options, because a lot of people get judgments against them or pay when they don't owe these financial obligations. So that is the theme. If there's one thing that I can really, like, you know, try and communicate on this webinar today, it's that we need to educate ourselves and our consumers even before they come through the doors. And, you know, like to the degree that we can do any kind of advertising, free or whatever, I always try and communicate the fact that, hey, you don't have to pay, and these are rights that you have that you may not know that you have. And then try and empower them with additional information once they actually get on the phone with us or on a Zoom with us to say, hey, you need to do X, Y, and Z in order to build additional evidence and empower yourself.
So I'm going to pause here for a question. We have a number of registrants today who are personal injury attorneys. And if you could, Abbas, the question is, talk about how some of these consumer laws might be impactful for a plaintiff, for example, who's been in a motor vehicle accident or has a workers' comp claim. And I think immediately of medical collectors, but could you talk about that just
Absolutely.
a little bit?
Yeah, absolutely. So, I mean, I think it would behoove most people that concentrate in a personal injury space to talk to, like, you know, somebody that concentrates in the consumer world, because there is way more synergy between those areas of law than you would first think, and you've kind of touched upon one. And I mean, there are so many ways. So, like, we work with a lot of PI lawyers at our firm, and one of the things that we say is, like, listen, your client gets into an accident, and immediately there's going to be medical providers that immediately try to insert a lien on your case. And so the first being the hospital, and the first being the ambulance company, and the second the hospital, right? Mm-hmm. And so they have, like, the people that work with our firm, for example, have made it part and parcel of their practice that they immediately send a representation letter to the ambulance company and to the hospital saying, regarding pretty much anything, we represent, you know, Mr. John Smith, right? Because who was hurt in this accident. And of course, about 20–30% of the time, the ambulance collection companies that have a $800 to $1,200 bill outstanding can't help themselves. What do? They send the collection letters to the client directly. Now, in California, we have a statute that sisters the FDCPA. FDCPA only applies to third-party debt collectors, but the Rosenthal Act also applies to original creditors. So the minute, and it's a strict liability statute. So wow. So let's say the lawyer on a Monday sends a representation letter to the ambulance company, and then on the Tuesday the ambulance company sends a letter to, or a phone call even, to the consumer saying, hey, you owe us $850. Well, that's immediately a violation of the Rosenthal Act, like right there and then. And so what happens there is it's not a huge case. No one's going to become a millionaire. The statutory damages on the Rosenthal Act are up to $1,000 per case. Well, guess what usually happens? That lien goes away. And we can't guarantee that. On the best, what could they? Would they have the option of paying the statutory damages and or waiving the debt, and then they have to pay attorney's fees on top of that? So, wow. So the attorney usually gets a couple bucks for the client. Usually, though it's not guaranteed and not part of the statutory mechanism of the Rosenthal, but it inevitably happens, they waive the debt, and then they throw a few $1,000s at the attorney if they settle it on the pleadings. If they want to litigate it, they'll make a $7,500 case into a $750,000 case. Because and what's beautiful about the Rosenthal Act, for example, is, and the FDCPA for that matter, is that they're one-way shifting attorney's fees. If the defense wins, they only get costs, but if they lose, they have to pay costs and fees. And it's wow. And it's a shall pay reasonable fees. It's not a may, it's a shall. So it's mandatory. So that's just one way. Now, in the class action realm, products liability and product defects are a massive area. So you're a personal injury attorney. You've got a client that has been severely hurt in, let's say, a rollover accident, or something happened to the vehicle that caused an accident, right? How much extra time would it take for that personal injury attorney just to go on the forums, or have a clerk go on the forums to say, is this a frequent defect in this type of vehicle with this make and this year? Mm-hmm. Well, guess what? Potentially nothing happens to your personal injury case, but you may also have a big product liability, product defect class action that you're sitting on that people just ignore usually. Wow. Like then you've got, of course, people's medical lien holders and debt collectors. If the case goes on for a while, and you have an aggressive medical holder or a lien holder or a medical collector, and which then goes to third parties, they start sending letters or even actually dinging people's credits. Well, if you have an agreement that the bill doesn't get paid until there is a recovery, then they have violated that agreement. It's both a collection violation and an inaccurate credit report violation, because if they're saying you're delinquent, you're technically not delinquent yet because there's been no settlement or verdict and the case is not ended. So they don't have a right to put anything on your credit report. And I know obviously time is somewhat limited on this webinar. Just those are three things that come across personal injury lawyers' desks on a routine basis. And so there are a plethora of other ways that consumer law and personal injury law overlap and have synergy. But those are three kind of simple examples that you can get into. And I honestly welcome anybody to take a lunch with a consumer attorney in their area just to kind of find out about what else there is, because it enhances the powers of the consumer. And of course, it's a benefit to the lawyer as well, because most of these things have attorney's fees. So it's a benefit for everybody involved.
Well, thank you. And I think that's, like you said, very relevant examples to help lawyers understand, as you described, the synergy between pure personal injury work and the consumer law that you practice. So thank you for that.
Of course.
And so now let's, I guess, turn our topics to these items: case management, communication, actual courtroom strategy. Where would you like to start with that?
I think, case management, I think, is important irrespective of what area of law you're in, because it obviously is going to help you organize your practice, your calendaring, deadlines, statutes of limitations. But it's even more important if you have a high volume practice or deal with kind of mass torts or mass arbitrations, for example, where you're dealing with thousands of consumers in one case, for example. So no, and obviously you have a duty to communicate with clients. There's things like conflict waivers that you have to have signed if you're representing a ton of people on the same issue that's kind of being collectively litigated. And software and case management definitively help with that, because you can write template letters that apply to all your clients that will automate communication. It will alert you that you haven't talked to clients for a certain amount of time. It will alert you of when the statutes of limitations for every single case is due, because you're still doing the intake on an individual basis, even if you're signing up to 5,000, 10,000 clients. And so your intake specialists are putting that data into your software, which will basically trigger the statutes of limitations and automatically calendar and things like that. And of course, with courtroom strategies as well, like, I mean, in litigation, the more data that you collect, the more information you have. And like, for example, you can use your software to run reports, to look at patterns, to look where it's best to file a particular type of case. And so the accumulation of data and the use of management can be both not just on more logistical and procedural grounds, but you can definitely use them for strategies when you begin to study that data and use it effectively. I think it behooves most practitioners to really see what kind of data sets that they actually have and how they can use those data sets more effectively in strategizing a case. Of forum is a very good example. Like if you're putting in the right amount of data, you know how many judges are in just each jurisdiction, and if you have the ability to know who the judges are, it says, well, if there's 4 judges in one particular venue and you file in that venue, you got a 25% of getting one of those judges, for example. And then you can it's like, well, do I want one of those 4? Can I live with those? Is that best for my client? And to much more kind of like numerically driven data points. So for example, a particular insurance company on a certain type of case is settling cases for this kind of delta, like these are the bookends. So that if a number is one side or the other, you're outside the norm, and it could be too high or it could be too low. Well, too high is always a good problem to have from a plaintiff's attorney, but it's generally on the other. But you can build in parameters for yourself, and that obviously informs the negotiations with the adjuster or the defense counsel. So I think case management software in modern practice is almost essential. Like, I mean, can you practice without it? Of course, but I think it gives you additional tools and additional bandwidth, because you can automate so much. Whether it's retainer agreements, whether it's termination letters. So it enhances your workforce to be able to do more work in the same time period without hiring additional people. So it's almost false economy not getting a good case management software, because you are having to do more work, which means you can service less clients and help less people. So it's like from I think if you speak to most people, irrespective of the area of law that they're in, most people would probably agree with that sentiment.
I think so. I've saved my favorite topic for last. And so I know everyone would love to hear some of your stories about successful cases. And I'm going to put you on the spot just a minute and ask you to start. Is it Knutson? Am I saying that right?
Yeah. That's actually a good. That's a good case. So that was one of. It's a seminal case on the issue of formation in the arbitration context in the Ninth Circuit, but it was kind of a crazy fact. And this is post Concepcion versus AT&T, which a lot of plaintiffs practitioners thought is going to change the way that we practice law in the class action world, because arbitration agreements even today are so relevant, and they moot the ability to bring forth meritorious class actions. And the Knudsen case is a really, really good example of that, where SiriusXM tried to basically stop a class action that would have saved them millions and millions of dollars if they had succeeded. And they did so at the district court level. And the basic facts were this, and you are somewhat putting me on the spot because it's over a decade old now, but I remember the facts pretty well. So Mr. Knudsen goes to a Toyota dealer and he buys a brand new truck. And when he's there, they tell him, hey, Mr. Knudsen, we're gonna give you 90 days free XM radio. And he said, well, thank you very much. And off he goes. So then after he goes, allegedly, a welcome kit came into and was sent to him 30 days after that transaction from SiriusXM Radio. And buried in this welcome kit was a contract with small print that said, by the way, unless you respond, this is brilliant, right? Unless you respond within 10 days of you purchasing your vehicle, you're bound by the terms of this agreement. Now, remember, they sent this 30 days after the transaction, but he was bound by this alleged agreement that allegedly bound him 20 days before he had any type of notice for it. And so after that, he starts getting hounded by robocalls, and they were unsolicited, and there was no prior express written consent as the Telephone Consumer Protection Act requires. So we sued SiriusXM Radio for violations of the Telephone Consumer Protection Act, which allow consumers to get $500 or $1,500 per call, right?
Wow.
And you can just imagine how many calls SiriusXM makes soliciting new clients, because they knew that at the end of the 90 days, the free XM would end, and they wanted him to subscribe. That was the intent of the call. So pure marketing. And so we sued them, and they brought a motion to compel arbitration at the district court level. And at the district court, they won the motion to compel arbitration. And I didn't understand it. I'm like, well, how are you binding my client to an arbitration agreement when there was no agreement that he was aware of? It's a pure due process issue, and it's a contract formation issue. So we went to the Ninth Circuit, and I argued that case. And it was kind of intimidating because, you know, like you got a national law firm that brings in their appellate specialist that, you know, has done this, argued in front of the Supreme Court, this and that. And at the end of the day, if you have good facts, the chances are you're going to make good law, right? And so we had really good facts, and it was just totally unconscionable. And but that's not the argument we were going for, because unconscionability had kind of been done away with in the Concepcion case. So we were arguing pure formation and due process. And really, we won the day 3-0 at the Ninth Circuit on that. And ultimately, that case settled for, I think, $35 million. I mean, that's a really, really good example that, like, you know, you need to not necessarily, like, we all get bad opinions come down in our areas of law, and the first couple of weeks is hard to deal with, and you think it's all doom and gloom and reality. And it's actually the ability to be able to manipulate and massage these opinions for your benefit of your clients. And mass arbitrations is a really, really good example of, like, the derivative of the Concepcion and the line of cases that came thereafter, all the way through Italia Colors, all the way to the Epic Systems case that came out a few years ago, because everyone thought, well, class actions are kind of dead. And of course, the response to that has been, well, what's good for the goose is good for the gander. And so the response to that is been, like, hitting the defense bar where it hurts, which is their pocketbook, which is what mass arbitrations does. And now they are responding to that by basically using their leverage with the ADR providers to change their policies and procedures in order to make it more economical for them to do mass arbitrations, which is already bringing the next round of litigation. And I'm kind of, like, you know, digressing from my story about, you know, a successful consumer law case, but it's interesting to watch the pattern and how the evolution of cases in the consumer world has moved just in a decade or 15 years.
That's fantastic. And again, sorry to put you on the spot, but that is, it was such an important case. As you think about it today, Abbas, is there another case or another example that you feel could be helpful to our attendees?
You know, like, the answer is yes. I think I'm actually going to go a little. I mean, most of the cases that I personally am are somewhat known for tend to be class actions, but some of my favorite cases are individual cases because you get to be a little bit more imaginative, and I think using your imagination and being a creative lawyer makes you sometimes the best lawyer. And there was a case where we had two elderly clients, and they kind of came to us because they were being evicted, and they were in their 80s. We're not just talking about like, you know, they were in their 60s. They were in their 80s, and it was an eviction case where they were being thrown out of their apartment, and they'd had a notice put on their door, and because they're elderly, they didn't really do much about it. Next thing they know, they're in court in a unlawful detainer action, and they get a judgment against them. And so they're like, we don't want to leave our house. Can you help us? And they were pro per in the court when they had that action against them. And it was, you know, like in the bigger picture of things, a very, very small case, but obviously it meant the world to these two individuals. And I really, really wanted to help them, and I couldn't figure out how. Excuse me. And so I took this personally, and I took this case myself, and I worked with an associate on it. And I was kind of, you know, we filed a very, very thin case in federal district court for the Southern District of California, and under the FDCPA, because we were like, well, you were using unconscionable means to basically collect from elderly people and allege some elder abuse statutes. And at the beginning of that case, they were threatening sanctions against us, and they were saying it's not a meritorious case. And we did we did just enough to get into discovery. And I took a deposition, and I got the attorney that did the unlawful detainer action to admit to me that she spoke to my clients in the hallway, because what happens in these cases, you go there and the judge goes, before I make a ruling, go in the hallway and see if you can work it out. And so the attorneys know this is going to happen, so they pull all the defendants into the court, into the hallway, so by the time they get in front of the judge, they can always say, we've already done that, judge, so just give us the judgment. So they had this conversation, and I got the judge and I got the attorney to say, yeah, well, that was the first time I ever saw them and I ever spoke to them. And apart from the legal documents that had been sent to the clients, nothing else had ever been said. And so that was the first communication from these attorneys, that all they did was do unlawful detainer actions. So they were debt collectors under the purview of the FDCPA. So I immediately amended my case and alleged it as a class action, saying that because under the FDCPA, you're obligated to send a writing to the consumer within 5 days of your first communication with a whole enumerated list of the things that the statute mandates you to explain to the consumer, because it's seen through the purview of the least sophisticated consumer. And so I was like, well, you told me in your deposition that this is what you always do. So you're not giving these consumers their notice under the FDCPA as required. Well, guess what? The said individuals were paid 6 figures by these people, which enabled them to get into another house. And it was just kind of us thinking on the fly and being a little bit creative with the statute, and using the opportunity of discovery to really go fishing in order to find something else that gives the clients much more leverage in order to be able to change the dynamic of litigation. And that's always kind of stood out to me, and that's something I always use with associates, because I'm like, you have to think outside the box. And so that's another case that I would put there. It's not necessarily the best and the most numerically fancy case that I've ever had, but it meant a lot to those individuals. And for them, that kind of money was life-changing. And that was done because we were being creative. And so that's a lesson learned, is that creativity does actually bear fruit.
That's fantastic. And, you know, Abbas, that's one of my favorite things about working with trial lawyers is not only do you work hard to help your clients, these elderly plaintiffs that you had in this case, but by doing those things and thinking outside the box, you're paving the way to help a lot more people and to make corporate America and these big insurance companies maybe think twice about those crazy practices that they engage in. It's a high calling, and I applaud you. That's a great story. Thanks for sharing it.
Thank you. I appreciate that.
All right, so before we start to take questions or other comments from our attendees, Abbas, in summary or wrap up, is there anything else that you'd like to share with our attendees today?
No, I mean, just I told you the messaging today is all about education. Educate yourselves, and most importantly, educate your clients or would-be clients, because I think that's what's going to help everybody. It's going to help them, and it's going to help you it's going to enable you as the lawyer to help your clients in a better way.
Right. And so I think it's the education theme is spot on. For example, our question about what I call, you know, general practitioners who handle personal injury cases to understand how these various consumer protection laws apply and can be instrumental in things like a motor vehicle case or a slip and fall or other tort type cases. Does anything else come to mind when you think about those types of cases where consumer protection laws might be instrumental?
I mean, there's so much, like, you know,
Yeah.
for example, like in another area where we do a lot of class actions, where we work with personal injury lawyers, is where there's a total loss claim on a vehicle, for example. The insurance company buys the vehicle at fair market value, but what sometimes they don't do is pay the pro rata of the remainder of the tax and the registration. And in the cumulative, if you're dealing with a massive insurance company, that's millions of dollars that they are taking from the consumer, because they're meant to, when you buy the vehicle, you're also meant to compensate the consumer for the remainder of the registration and the tax that they've paid on it, which they don't sometimes. So those are really, really good class actions. But I could sit here and just talk for hours on how many different ways you can pick up cases that are class actions in the PI realm, you know, products liability and, you know, things like this. For example, right now we just filed a really big case against the Department of Motor Vehicles for you know, the way that they make people renew their registrations. And so that could have been something that came from a personal injury lawyer. In this particular case, I actually didn't, but that could have totally come from a personal injury lawyer, because they have direct communication with clients in that realm. And so, you know, the list can go on and on and on.
So if someone wanted to contact your firm or, you know, inquire about something that they have relative to a current case or a possible future case, we've got your contact information displayed here, Abbas. Is email or call preferred? Do you have any preferred way for them to reach out to you?
I mean, if they want to reach out personally to me, I'm usually on the road. So email is the best way. It's ak@kazlg.com. But of course, you're very welcome to make a phone call. It's 800-400-6808. And I mean, I'm very responsive. I will get back to you, but usually a quicker response will come via email.
Okay. Perfect. And just wanted to give a shout out. Thanks everyone for joining us today. It's been super informative, lots of details, lots of great information. If you have another topic that you would like to see a webinar for, please feel free to reach out to us and we'd be glad to get that in the works. And I think that's it for today. Thanks so much, everyone.
Thank you.